Hello, everyone. My name is Don Greene, and I'm here at Rigel Studios in Las Vegas, Nevada, and we're continuing in an analysis of some recent Supreme Court decisions which will impact the firearms owners in Nevada and California, where I principally practice law. Today, to assist me in an analysis of the now important decision of Relentless, which overruled the Chevron agency discretion decision just last week, is Maggie Mordaunt from Homeland Protection Training. And Ms. Mordaunt, please introduce yourself.
My name is Maggie Mordaunt. I'm better known as CCW Maggie, owner of Homeland Personal Protection. I'm a defensive firearms training instructor. You can typically find me at Bass Pro Shops or in some of your local ranges here in Las Vegas.
Okay, thank you. Again, let's get right into it. Let's have the first slide. In the past few weeks, past 10 days, the United States Supreme Court, in an amazing decision, reversed the what's known as the Chevron case. And basically, Chevron stated back in the 1980s, a U.S. Supreme Court decision, that courts should defer to an agency's interpretation of its own regulations, where maybe there's some ambiguity in the regulation. The U.S. Supreme Court has been waiting for years, and until last week, Chevron was the law of the land. Now, Relentless, in an incredible decision, has stated the following, that the courts are the ultimate arbiters of the law. And what the Chief Justice did in this decision is that he reinforced the U.S. Supreme Court as a co-equal branch of government. And for years now, there's been a lot of turmoil at the Supreme Court, overruling Roe versus Wade, the gay marriage decision in Masterpiece Cake, some of the other decisions which have come out over the years. And the Supreme Court has literally been getting beat up. And in fact, as we speak, there are some futile attempts to impeach two of the justices without the complaining member of the House of Representatives really understanding the principles under Article 3 of the United States Constitution, for which he has no clue what it's about. But in any event, in the Relentless decision, it's not so much the facts which are important. What is important is that the agency attempted to show that, well, we have wide discretion, we can decide these particular things. And it went up to the U.S. Supreme Court, and we'll get into how it affects our gun rights people and our gun owners, our listening audience, our viewing audience, who wants to understand, how does this affect me? So tell us, Maggie, when you're instructing in your classes, you always talk about the law, the ATF, the FBI background checks, and the Las Vegas Metropolitan Police Department, and how it's their decision on whether somebody can get a firearm or a CCW. Tell us a little bit about what you instruct your particular students.
So there are multiple laws that we do talk about in our concealed carry weapons classes. When it comes to the choices that individuals make and how they look into how the laws can affect them personally, when we have bureaucrats who are trying to invoke or place upon others what they think, and maybe these anti-gunners, the bureaucratics, who are coming in and trying to enforce things that may actually involve taking away our rights as Americans to keep and bear arms. I tell a lot of my students that they really do need to do the research. With those rights comes responsibilities. Our Constitution needs to be protected, especially when you have individuals who maybe if they can't make those decisions, they're going to try and throw it off onto some other agencies, which I'm kind of seeing here. With this case, I'm telling my students, we as Americans can't sit around and wait for somebody else to protect our rights. We have to dig in and get those rights protected ourselves. And so having their voices heard and getting out there and putting in the effort to make sure that they educate themselves, getting out there. I mean, we have the internet that has a lot of great information out there, or contact a legal representation to find out more about it. Don is actually such an expert at this, and he's got some great information that you should be looking at. And so when it comes to in our classes, we have to tell our students with rights comes responsibilities. And not only is a CCW class just an informational class, but it's also something they have to get out there and take training so they know what to practice. And when they get into those polls and they know what to look at, there's a lot of detail in a lot of the information that they're looking at. And if they don't understand it at the time before they get to that poll, they actually need to get in there and get the information before they make that important decision that may impact them and all the people that are in that class with them as well.
Thank you. Let's go to the next slide. Now, some lawyers, many people don't understand that almost 200 years ago, the U.S. Supreme Court reinforced its position as a co-equal branch of government in two very famous decisions in Marbury versus Madison in 1806, followed by another decision called McCulloch versus Maryland. And these decisions, McCulloch specifically is referred to by the Chief Justice, and is showing that the Supreme Court is the ultimate, and the courts in general, are the ultimate arbiters of what the law means. May we have the next slide? So what is the effect on firearms regulation? And we'll ask Maggie a couple of questions. Maggie, people come to you, I take it, during the classes and say, listen, a few years ago, I may have had a problem at school when I was a school teacher and I was relieved of duty, and the school board made a decision, and now it's on my record, and now someone says I can't get a firearm. Now, that's, I'm making that particular, that is a real, based on a real case a couple of years ago. But what I'm saying is, when you tell your students, here's what you have to do. This is an agency which has made a decision, and you need to challenge that decision, but what would you tell your people to do in order to get their material together to challenge an agency finding, such as an issue which comes up in this Relentless decision?
So in this case, we would really want them to seek great legal counsel, find out exactly what they need to bring to court to appeal, what they need to have in their requests of what they want to be seen. So if they have something like a restraining order, or if they had some sort of domestic case or something like that, or if they, I don't know, maybe for CCW, if they had a DUI, certain things like that may actually affect their ability to even get a firearm or concealed carry weapon license, that is. And so making sure they understand that there are specific ways that they can actually go in, appeal that, have it reduced, or even have it removed at some point. Maybe they need to go take another training course that actually helps them get more educated on that subject. I have lots of students who come in because maybe they have a court-ordered class that they have to come in and take, and so that would satisfy that at least they're making an effort to do something to be much more responsible with that education.
Let's get into a specific. Someone has what could be classified as a voluntary placement in a psychiatric facility, and someone who has an involuntary placement in a psychiatric facility. And so what we have to do is, there's an agency determination. Professionals have decided it was a voluntary. It's a lot easier to say, look, I was just feeling bad because my mother was ill or whatever. I needed to get away from my wife, and I placed myself into a voluntary situation. I was only 25 years old. Now I'm 50, and it's affecting me. But a lot of people don't realize that these things require a great deal of effort to try to get them straightened out. Would you agree?
I do agree with that,
and
yes.
Would you agree that with some of the people who come in, let's say a DUI, well, it was a DUI reduced to a reckless driving.
Correct.
And can you get let's say a DUI, can you get a CCW if you had a DUI 3 years ago?
No, you cannot. You have to wait 5 years.
5 years. Now, suppose you want to challenge that. It's not going to go very far, but what it is suppose that there's a question as to whether your DUI was 5 years from the date of conviction, the date of arrest, or the date of the final adjudication. So what would you tell your students to do to gather their material? Because they're going to end up before an administrative agency, such as the Concealed Weapons Bureau of the police department, which they're good people.
Yes.
But they got to apply the law. So what would you tell your students to do in that DUI situation?
So they want to provide the documentation that shows when they were actually convicted of domestic violence. And so they can show that the time period that they need to stay in place and wait has actually been satisfied. Make sure that they do bring copies because don't expect them to make copies for you, although they can be really cool about doing that. But, just to kind of speed up the process, bring some copies of that, but also bring the originals as well so they can see that as well.
Okay. Now, as it applying the Relentless decision, we have the Las Vegas Metropolitan Police Department, which has provisionally denied a CCW because we don't know whether it was a voluntary entry into a psychiatric facility for 72 hours or whether it was one of those. In California, I think it's called a 1550 hold. Under the California Health and Professions Code or the California Penal Code, it's a 1550. And then whether it was that, whether it was involuntary. So, and the decision which is made by Metro, have you had any, in your experience, I know I had mine, have you had decisions where Metro has reversed itself and said, okay, we'll give you a CCW?
Yes, I have. I had a young lady who was abducted. She was kept for 3 months by some gang members. When they found her in the alley, almost dead, she was pregnant. And so she decided that in order to protect the baby, she admitted herself into a mental institution. And then, after she gave birth to this baby, made the decision to keep the baby. Amazingly, I got to meet this 14-year-old beautiful child. And so for her, when she came in to take the class and she went to submit her documents, they denied her because they said that she'd been found judicially declared mentally incompetent. Now, in that case, it showed that she herself admitted herself into the hospital, but when they put the records together, when she was in court during this case, they actually wrote it down wrong, saying that she was judicially declared mentally incompetent and went into this mental institution for that time period. And so she had to go in and appeal that and have those records rewritten and even sealed for that matter, so that she could continue forth and go into and take firearms training along with getting that concealed carry weapons license.
Now, I've had a situation in the last year about this time in which my client was denied a renewal of a CCW because what happened is that several years ago he went through a drug rehabilitation program through the drug court program, which suspended all proceedings against him, and at the end his case was dismissed. But somehow or another, that wasn't transmitted. What was transmitted was a judgment of conviction. There was no judgment of conviction ever. And in fact, in the actual documents referring my client to the drug court and drug rehabilitation program, he was much younger, 20 years ago, it was stated clearly, there is no adjudication. Proceedings are suspended. So we had to file, once he was denied, the CCW renewal by the Las Vegas Metropolitan Police Department, again, which had its paperwork showing this, but they didn't go through the actual documentation. We filed a petition for judicial review in the district court. And by law, only the district court has jurisdiction over administrative agencies in Nevada on a petition for judicial review. So in Nevada, we had the court do exactly what Relentless, this was a year ago, what Relentless allows it. We as the court are deciding what is going on with this paperwork and how this applies to the individual case in front of it. So I applaud the Relentless decision, and I think that I can't remember what department it was last year, and if I see the judge at a judicial function, I will mention it to her that that we got the case all resolved, and it was basically a preamble to this particular the Relentless decision, and we won. And the lawyers for the Las Vegas Metropolitan Police Department, once they saw how we applied everything, we went to the agency. We showed how the agency's interpretation of its regulation was incorrect as a matter of law, because the facts showed that there was no conviction. So that's how we're bringing to bear the Relentless decision on what happens with our audience, particularly focusing on firearms and their rights to own firearms. So would you advise the listening audience and viewing audience, Ms. Mordell, to, if they have a problem with their firearms, if they think that maybe there's something close to this? I had one this morning while I was sitting here. While I was sitting waiting for preparation for today, discussing issues with a man who had something from years ago, who thought the matter had been administratively expunged in another state in which I'm licensed, and he was advised that this is the procedure which we need to go through in order to present it to the administrative agency. So, what would you advise? Your students come in. Do you have a process by which do you ask them if they have a particular problem which might prevent them from owning a firearm, or do they come up and tell you just like during the breaks?
So for us, we do have a very large class. There are times where throughout the class, we are afforded the ability to take that time and go in and do a little bit of a background check as we see students kind of come through. If they do say, hey, I had this thing, because we do have a list that we go through in the classroom to say, do you have any of these things that you may actually have in your life? Have you had a DUI? Are you using marijuana? Have you been convicted of any of these things? And so we go in and we look at, was it dismissed? Is it something that's still there? And that they may not even know that could affect them when it comes to owning, using, or possessing firearms, or even taking the concealed carry weapons class. Now, sometimes in our classes, we actually provide the guns and the ammunition for the students as a part of their tuition. And so for us, we have to check to make sure anybody who's using our guns, that we look to see to make sure that they have nothing on their record before I put a gun in their hand.
Okay, now, Nevada's legislature only meets every odd year. So we have a new legislature coming in January of 2025. And there's a bill draft review, as I understand it, from the last legislative session in 2023, was tabled at committee. But I have a feeling that the concealed weapon class requirements may require a pre-background check prior to taking the CCW. Now, tell us what your thoughts are on that.
Wow. To put forth a committee or even a portal where someone would have to go, I don't know what the cost would be for that, or how someone would show up with a form that states that they did a background check or that they had to do this background check. I don't know that it's something that is a need. I think it is something that we don't get students who show up typically who are brazen enough to come and take the class knowing that they're not supposed to be there. It's really more the student who didn't know. So I don't know that there's studies to show that this is something that is, I think it's a bit of an overreach, quite honestly. I think for someone to have to go to be put into that place of having to do that, and then my question is, how much are they going to charge them for that? So I kind of feel like it's another hurdle that's been put into place where someone has to come and take a background check first before they can take a class. I mean, even in my classes, I tell students, look, There is a law in place where you have to take an 8-hour class, pass a background check in order to get a plastic card to conceal carry a firearm. Now, I also tell my students when it comes to our Second Amendment, that class, I think it's a beneficial class in the sense that they're coming in and they're taking training on information that they wouldn't have otherwise gone in and looked for themselves, which, again, I tell people, don't be lazy. If you're going to do something, be all in, do your due diligence, learn the information. But there are individuals in our state who feel that a CCW class should be mandated because people are not doing their due diligence. I love teaching CCW classes. I love the information that I can teach students. But at the end of the day, I'd like to teach a class where it's just based on firearms knowledge and information and the laws that are in place in our state and not call it a CCW class. Because quite honestly, a CCW class is an infringement on your Second Amendment right to keep and bear arms. Why should you have to take a class to cover up a gun on your body or carry it in a bag on your body? I really feel that there is a class that maybe people should take the initiative on their own, that it's not a forced class. Just putting it out there, I believe in our right to keep and bear arms. I know people are probably like, I'm crazy for saying that, but CCW Maggie, I'm a concealed carrying woman. That's really what that means. It doesn't mean I'm forcing you to come and take a class so you can cover up your gun. Again, I love teaching CCW classes because students get so much out of it and understand the laws and things that they wouldn't have otherwise known had they not taken that class.
So again, we do have features in place in Nevada, not so much in California. It's a little bit more difficult in California. It's more streamlined in Nevada, such as the petition for judicial review, actually going to Metro directly. I go to Metro directly when I have a particular issue, which I think can be resolved in the administrative process. And again, although Metro has been very good in interpreting its regulations, and they are very diligent, and a lot of people don't realize that there's a lot behind the scenes in a background check that you never see until you actually file what's known as a petition for judicial review. Then you get the record from Metro, which shows a phone call on March 1st to FBI regarding Mr. Smith. Response from FBI is that he had a battery domestic violence in Florida. The disposition is unknown, but then there was another case that he had in Indiana where he pled from battery domestic violence to illegal parking. You're still going to get denied because it doesn't matter. So there are some issues that can be which can be ambiguities, such as the FBI has a policy, and I've got an actual opinion letter which I carry around with me 7 days a week, 24 hours a day from the FBI in response to a request that I made, is that if a person is convicted of a crime, but it's not battery domestic violence, is he or she still prohibited? The answer is yes. It doesn't matter what you call it, according to the FBI, so long as the original components, the relationship, the illegal, unlawful touching, the fact that the touching occurred, the fact that the touching was non-consensual, and especially that relationship, we don't care what you call it, if it was reduced to illegal dog catching or assault with a deadly weapon or disturbing the peace. I get these calls all day long from attorneys, and I say, listen, I'm on the first floor, meet me at the snack bar, and I'll show you the opinion letter. So there may be room. There may be room. So Maggie and I, the purpose today for Maggie and I is to tell you that although there's this big decision of the United States Supreme Court overruling Chevron, how it affects the day-to-day concealed carry holder or those wishing to purchase, own, and carry firearms here in Nevada and California. We hope that may we have the last slide, please? Okay. We're hoping that there may be a balance between firearms and the judges. And I think that the decision in Cargill on the bump stock decision, the decision in Rimini from the past couple of weeks, and the decision in Relentless will show that the courts have the right and the obligation to decide what the law is. So we have some remedy there against overreaching federal agencies. Now, again, the FBI, the people that work at that FBI center, at the Nick Center in Clarksburg, West Virginia, are all good people. It's a huge facility, and they're to be commended. But then again, I'm sure that their legal teams are probably briefing all of them on regulations. But we wanted to make sure that not so much that we're showing you how a big decision is affecting you, but in fact, you need to be aware of that. And again, thank you so much, Ms. Mordaunt. And her contact information will be in the streamer below, as with me, 702-409-8239. You can call me 24 hours a day. And thank you again, and good day.